We are graced with the presence of David Rivkin, partner of Baker and Hostetler. He served in the Justice Department during the Reagan and George H.W. Bush administrations, representing 26 states in this challenge to Obamacare. I just have two quick questions. One question, Chris wants to ask you a question. Is this a meaningful question? Is there a member of the Supreme Court who you admire for just sheer reasoning power, mental power on these cases? Who's the powerhouse legal analyst?
It's a tough choice between Scalia and Thomas, but I would say probably Thomas, if only because Scalia gets his fair share of accolades, and Thomas is consistently underestimated and pilloried, particularly by the left.
Amazing. Good. Very good. Very interesting. Good to hear. Chris, the question we get in terms of emails and callers, but let's ask David.
Right. Mr. Rivkin, we get a lot of questions about severability in Obamacare, and I understand that the court's going to address this on Wednesday. Can you shed some light on this? As we understand it, the law doesn't have a severability clause, but the answer really isn't that simple, is it?
No, the answer is not simple, and you look to the legislative intent. The key question is, with the individual mandate going down, as I very much believe it will, would the rest of the statute work as Congress intended it to work? Now, the administration itself has argued throughout this case that the insurance industry reforms, the so-called no denial for pre-existing condition and no individualized underwriting, which basically means everybody's going to pay the same amount, cannot function without the mandate. So we are optimistic that the way Congress has designed the statute with the Medicaid changes, with the insurance industry reforms, and with the individual mandate are so tightly integrated, and again, integrated as Congress intended them to, that the entire statute would go down. Severability, again, is something you deal with after you win on a major provision like the individual mandate, and the question is, does the rest of the statute come down, or is it only the individual mandate?
All right, two other questions, perspective questions. Joe in Florida. Go ahead, Joe. Joe?
As much as I'm against the health care bill, I believe precedent has been set by the No Child Left Behind. Normal function of life is reproduction. If you reproduce, you have to purchase an education for your child by law. And if you can't afford it, you have to give your children to the government for 40 hours a week.
Thanks, Joe.
Well, this is, as I understand the question, this is kind of a permutation of a government's point, which is this is not general police power. We're really, the mandate is supported by the notion that everybody at some point in time is going to require medical care. The short answer is yes. If the statute said that at the time you require medical care, the only way you can pay for it is by having insurance. You have a card, and you cannot pay cash or a check or any other way. That would be stupid policy-wise, but constitutional. What you cannot do is you cannot impact people today because they might, or even certain, will purchase something tomorrow. Because if you think about it for a second, caller, to put it this way, is nothing more than regulating you because you exist. And that's general police power. And that's also unlimited because, look, you're certain to have nutrition in your life. Otherwise, you're going to perish. Hydration, transportation, housing. Just because you're certain eventually to require those things, and some of them are quite frequent intervals, can the government regulate you now? Doesn't work like that.
All right. So I'm very taken with this. So back to the wheat and the weed. If you don't touch the wheat and the weed, you're kind of free of the Commerce Clause, right?
Absolutely. Cannot ensnare you. You have to touch it or use it or some other things with it. But it's always, if you think about it, the Commerce Clause regulation always attaches to something other than you first.
Okay. And if you might reproduce, you're still safe from the demands of the law. Once you reproduce and have a child, then the law gets you.
That's correct.
Okay, I got it. This is good. All right, Bo is in, where are you, Bo? In Burlington County, New Jersey. Go ahead, Bo.
Yeah, it seems to me that we've missed the whole bigger picture. Thomas Paine pointed out common sense, a long habit of not thinking a thing wrong, gives it a superficial appearance of being right and raises at first a formidable outcry in defense of custom. What business... Why does the government care what my health care cost is? It does not care what the cost of my ground beef is. It doesn't care about the cost of my loaf of bread. my mayonnaise that I put on my bread or my dozen eggs or anything else. It does a considerable amount to drive up the cost of my vehicle when it's time to buy a new one under a lot of mandates, which might have been good in the 70s and 80s when pollution was much bigger, but we've probably now reached the wall of limited returns. And it seems to me as if the government is in the healthcare business because it violated de Tocqueville's observation that American Republic will endure until the day Congress discovers it can bribe the public with the public's money. And they're in the healthcare business, and it shouldn't be in the healthcare business except for its own employees and the people who are willing to possibly make the ultimate sacrifice.
Okay, Bo.
Short answer. I understand your feelings. You just articulated very passionately classical libertarian criticism of administrative state. Let me just put it this way. I would like to win this case. We cannot, and we won't in this case, we cannot win this case by challenging the sort of extent of propriety of a government's interest in regulating health care, because frankly this dog would not hunt. Not under the case law that exists today.
Okay, good. Thank you. Thank you both. Very thoughtful. We pride ourselves on our audience. Our folks read books, which we're very happy about. Read some good books, too. As we close here, David, again, if this question makes sense, what is the kind of colloquy you'd like to hear today? Where would you like to hear the focus among the lawyers and the justices today and tomorrow?
Very
what would
much,
encourage you?
Today, Bill, no, it's an excellent question. Very much the focus on the limiting principles or absence thereof. And I would like to certainly hear this from Justices Scalia and Kennedy. One very quick concluding point, and this is not to not to kick the poor government. Typically, you get better in the case as you go along. The government, unfortunately, because their case is so bad, has not gotten better. They began the first piece of paper they filed to dismiss our claim in Northern District of Florida. They've been unable to articulate the limiting principle back to, if you can do this, why not the broccoli mandate of a car mandate? And unable to do it for the district court. They've been unable to do it in the 11th Circuit. They're still unable to do it. So questions like this posed to Solicitor General Barilli would not get good answer. All of their efforts to come up with it fail, which is very unusual in litigation. The reason for it is not because they're bad lawyers, they're excellent lawyers, because there's no good argument. There's no limiting principle between this mandate and an infinite variety of other mandates.
Okay, and you think this will be exploited in the discussion that goes on today and tomorrow?
Absolutely hopeful. That certainly was something that interested every single judge who's looked at this, because, again, without a limiting principle, we got general police power, and the Constitution that the framers wrote is no more.
Marvelous tour. Thank you very much. Stay close, please. We may want to talk to you again at the end of the week if you're available.
Would be my pleasure. Thanks.
Thank you, David. Thank you very much. Okay, good.